All right, so today we are delighted to have Judge Colette Rutel here to present to us on the Loper Bright case. And I will not belabor the point with a lengthy introduction. I'll just go ahead and turn it over to you, Judge.
Okay, thank you. Good afternoon, everyone. My name is Claire Rutel. As Ms. Larson indicated, I am a judge in the Fourth Judicial District, but I'm providing this presentation with my own views and interpretation of the Supreme Court's recent views on Loper Bright, really largely based on my time in academia. Before I was a judge in Hennepin County, I was a law professor at Mitchell Hamlin School of Law, and I still sometimes teach at the University of Minnesota's Law School and Mitchell Hamlin, and actually taught administrative law last semester, where I could preview for students what was likely to happen in this court case. It wasn't a shock, really, to anyone who follows administrative law and follows the Supreme Court's administrative law decisions in recent years. But with that said, it's a really significant decision because it did overturn precedent that has been really important in this area for the past 40 years. So I want to start by launching into some quick background. I know most of you are probably familiar with Chevron and the framework, so I'll be pretty brief here. The case itself, Chevron versus NRDC, is a case from the early 1980s, and it involved the Clean Air Act. And the question presented in the case was, what did the term stationary source mean in the Clean Air Act? And this was really important because the Act set up requirements for stationary sources to obtain permits if they were modified or if new stationary sources were built, if the jurisdiction was not yet in compliance with National Ambient Air Quality Standards, or NAAQS. So the EPA decided to use notice and comment rulemaking under the APA and define what a stationary source was. And the basic definition the EPA came up with is what we referred to as the bubble approach. So the EPA looked at stationary source as being the entire plant. And that's just a picture I cribbed off the internet. It's not actually Chevron's refinery site, but you can see how you can have multiple smokestacks within one plant. And the EPA said we should look at all of them together to see for the definition of stationary source. And that matters because if you're modifying one smokestack, that might not increase the emissions of the entire plant if you made adjustments elsewhere. And so it might prevent the plant owner from having to get that permit. The EPA's definition was challenged by the NRDC. And the question then became, was the EPA's definition in accordance with the Clean Air Act? The U.S. Supreme Court in this case, set out what we refer to now as Chevron deference. And in doing that, it upheld the agency's interpretation, reversing what the lower federal courts had done. And so what we commonly refer to as the Chevron two-step was created in this decision. And step one is, has Congress directly and clearly spoken to the precise question at issue, or is the statute silent or ambiguous? So to figure out whether the statute is clear or whether it's ambiguous, for the most part, I think courts have agreed that that they should employ normal tools of statutory construction. And I'll talk about that a little bit more, and we can look at what the Supreme Court did when it was interpreting the APA in its recent decision in Loper Bright. If the court does find the statute is either silent or ambiguous, it moves on to step two. If the statute is clear, obviously the court is going to require the agency conform to Congress's clear intent. But if there is silence or ambiguity, then we go to step two. And step two says, since Congress hasn't clearly addressed the issue, the court will defer to the agency's interpretation if it's reasonable, or said another way, if it's based on a permissible construction of the statute. So in other words, if the statute permits more than one reading, the court will give controlling weight to the agency's interpretation, even if it's not one that the court would have chosen in the first instance. And that was basically what the Chevron doctrine did. Chevron, when it was decided, was considered to be a case that actually supported separation of powers, even though it's not viewed that way by many today. The question the court was considering was not whether one side had a better interpretation of the statute, but instead who got to make the decision when there was silence or ambiguity. Was it going to be the court or was it going to be the agency? And so Chevron recognized that there were often choices between competing policies. And if traditional tools of statutory construction that you would apply in step one, if they didn't come up with an answer to the question, then the court felt that agencies were in a better position to resolve the policy questions. And a number of different justifications for that were provided. Agencies obviously have a lot of experience in administering the statutes that they've been directed to administer. They have, in many cases, technical expertise that might be important in interpreting the statute. And they're also more accountable, at least, than the court is to the people, directly through the president, who has the ability to appoint and remove heads of agencies. Whereas judges, federal judges anyways, are appointed for life and are supposed to be insulated from political pressure. So the idea here is that Congress likely wanted the agencies to make these decisions, not the courts, and that Congress had impliedly delegated that authority to agencies. So this rule in Chevron was binding precedent for over 40 years. And you can imagine it was used in a lot of decisions. I've seen counts say that it was around 18,000. I admit that I have not done the count myself. The interesting thing is that there have been a number of empirical studies of Chevron and how it impacted courts in their interpretation of statutes. And I'm not going to say that the studies are all consistent, but for the most part, the studies did conclude that affirmances, so affirming agency interpretations of statutes, rose pretty dramatically after Chevron. They had been trending upward in that direction, affirming agency interpretations of statutes. But an early study in 1990 in the Duke Law Review indicated that affirmances had increased by almost 15% following Chevron in just that couple of years. And then a much more comprehensive study completed in 2017 that was published in the Michigan Law Review by Ken Barnett and Christopher Walker concluded that a court was likely to find that the agency's interpretation prevailed if it followed Chevron by 77% versus de novo review, where it was down to 38.5%. Right, so that shows you that there was a substantial difference when the court was applying Chevron versus when the court was engaging in de novo review. I always think that the Barnett-Walker study is really interesting for another reason, and that is the data about the reduction in partisan voting following Chevron. And so the study looked at liberal panels on the Federal Court of Appeals as well as conservative panels and tried to figure out how frequently they voted to uphold the agency's interpretation. And liberal panels, they said, agreed with conservative agency statutory interpretations in only 18% of cases when Chevron deference wasn't used, but they agreed 51% of the time when it was used. And likewise, conservative panels agreed with liberal agency interpretations only 18% of the time when Chevron wasn't used, but 66% when it was used. So you can see those are a big difference if, again, the difference between a de novo review and then pairing that with potentially a liberal or conservative panel and then looking at what the end result would be under the Chevron doctrine. And those, I should say, those are the authors' descriptions based on, their take on whether a particular judge, is considered to be liberal or conservative, and then obviously based on the administration of the agency that was making the decision. Despite that and the reduction in partisanship, Chevron has fallen out of favor, and it's been falling out of favor for some time. Some of the backlash appears to have highlighted concerns about agency flip-flopping. And I'll say whether you use that phrase flip-flopping or flexibility probably shows whether you supported Chevron or didn't support Chevron. And both of them are really referring to when there's a change in presidential administration, does the interpretation of the federal statute change? What's interesting is that originally this was actually considered an advantage of Chevron, because it was viewed as flexibility. And without Chevron, there was a concern that if there was only one interpretation of the statute and you couldn't change the statute's meaning over time, except if you convinced the Supreme Court to change its interpretation or convinced Congress to amend the statute, then it would be really hard to keep up with society's problems and to address changes in technology and new issues. So at the beginning, this was seen as a positive, the flexibility provided by Chevron. Later on, obviously, it has been characterized more as flip-flopping, an agency drastically changing its positions when new administrations come in, and that has been part of the backlash against Chevron. One of the other thing that's also interesting is that originally Chevron was seen as quite a favorable decision by conservatives. The Reagan administration was in power at the time, and it was interested in deregulation. And the courts, on the other hand, were populated by more liberal justices. And Chevron was seen as a case that would give the Reagan administration greater flexibility to achieve its goals. And as a fun fact, it was actually Gorsuch's mother who was the head of the EPA when Chevron was up in the Supreme Court. And so the Supreme Court was actually deferring, in that case, to the EPA's decision headed by Justice Gorsuch at the time. It was Democrats that were initially skeptical of Chevron, and they felt it removed a necessary check that the courts would provide against administrative agencies. Obviously, the times have changed a lot. I think it was at some point in the Clinton administration that we really see the shift. It obviously became even more pronounced during the Obama administration. So at this point, you have Democratic presidents in charge of agencies, and agencies' agendas are now, less focused on deregulation and more focused on things like interpreting environmental statutes like the Endangered Species Act, with a pretty important case, the Sweet Home case that reached the Supreme Court, as well as directing actions more recently towards climate change and immigration reform. And now Chevron appears to be supported by Democrats and rejected by Republicans. The shift has also coincided with really a change in the way the Supreme Court interprets statutes. There has been a shift to finding more of the statute's plain meaning and relying on dictionary definitions and de-emphasizing other things like legislative history. And I will come back to that when we talk about what the court did, though, in Loper Bright, where it did rely on some of those other means of statutory construction. So because of that change, in terms of perspective and who was backing Chevron, the Trump administration did not advocate for Chevron to be used to uphold its policies. And the Supreme Court actually had not used Chevron in any cases since 2016. So while this is a Loper Bright, and overturning Chevron is a really significant decision in the lower federal courts, which have been relying on Chevron, in many, many, many cases. As you can see, there are 18,000 cases since it was first decided. The Supreme Court has not relied on it in a number of years at this point. And rather than rely on it, the Supreme Court has taken steps to whittle it away in some respects prior to Loper Bright. The one of those you could say would be the addition of step zero, as well as the major questions doctrine. So there was a lot of back and forth in the court about what types of agency interpretations were going to receive Chevron deference. And there has been a good deal of back and forth about whether it's only agency actions that are promulgated through notice and comment rulemaking, so go through that formal APA process, versus informal agency actions, things like guidelines, bulletins, handbooks, etc. And for the most part, there are one or two cases where you can say that don't fit this, but for the most part, the court has tended towards limiting Chevron to notice and comment rulemaking when providing that deference. In more recent years, in the Affordable Care Act case, as well as in the more recent decision, West Virginia versus EPA, the Supreme Court has just refused to apply Chevron, finding that the question that was involved, the issue involved in statutory interpretation was of such deep economic and political significance that it was a major question, and that Congress wouldn't be implied to have delegated that authority to the agency unless that delegation was clear. And so the court has refused to apply the Chevron framework in recent decisions based on that major questions doctrine. And one really wonders whether that doctrine would really have been emphasized and would have been so as important as it might be in the area of administrative law and elsewhere if Loper Bright had been decided earlier. But we are left now with both of those decisions. Looks like there is a question about, does Loper Bright distinguish between issues of legal interpretation and those of policy? Yes, I'll go into the decision. I'm actually just headed there, so I can tell you a little bit about what the court did. The court did leave room for some deference to agencies when Congress has actually delegated that authority in the minds of the court, and so I'll get into that in a moment. So Loper Bright, the decision, you probably don't know much about the facts of the case because they were largely ignored by the parties and by the court. The court didn't even really try to apply the statute at all, and just remanded at the end. The case, though, was about the Magnuson-Stevens Fishery Conservation and Management Act. And that act created 8, I think, regional fishery management councils. And those councils then make up management plans, and then those plans are sent to the National Marine Fishery Service, and through notice and comment rulemaking, they're adopted as regulations. So there are 8 councils that create plans that then go to the federal agency, and the federal agency adopts those plans through notice and comment rulemaking. The act does contain some language specifically about having government observers or government inspectors on certain fishing vessels. And it specifically notes that there are 3 groups that have to pay for these government inspectors, have to pay the costs. Foreign vessels, and that was, the involvement of foreign vessels in what the U.S. viewed to be its fishery was one of the reasons behind the passage of the act originally. And foreign vessels are required to always have government observers or inspectors on their ship and pay the costs associated with that. The act also specifically said North Pacific Council vessels had to pay the costs of government inspectors. That's the largest fishery in the U.S. And then vessels that were participating in certain programs where there were quotas for the fish involved. So the statute specified those three instances when government inspectors or observers had to be paid by the industry itself, and then capped the required payments to 2 to 3% of the value of harvested fish. Despite that, the New England Fishery Management Council had its own plan, which was then adopted by the agency, and it required the Atlantic herring fishery to pay observers under certain circumstances. And those costs ended up being a lot higher for most vessels than the 2 to 3%. They were typically around $700 a day, which in some cases could have been up to 20% of the takeaway for the boat. And so the challenge was to the National Marine Fisheries Service's decision to allow this plan to go into effect, or to, I should say, adopt it as a regulation, which allowed for or required vessels to fund those costs of observers, even though the statute didn't specifically state it. So if you're thinking about where that might fit in, whoops, going the wrong way there, in the Chevron framework, the Atlantic herring fishermen, they did file two separate lawsuits that were going on under the Administrative Procedures Act. And the agency won both at the district court level and at the federal appellate level in both of the cases that were then heard before the Supreme Court. The DC Circuit affirmed and basically said, when it comes to step one, that the statute was not wholly unambiguous. And so they were going to go to Chevron's second step, and then they deferred to the agency's interpretation, which they found to be reasonable. The First Circuit's opinion was a little bit more obtuse and didn't really specify which Chevron step it was using. If you just look at the facts in the statute, I think the hope would have been that the Supreme Court, if it was going to reverse, would have reversed on the ground that the statute itself was clear and unambiguous, and by identifying three instances where vessels had to pay for observers, cover the cost of observers, that excluded requiring other vessels to make those payments. But obviously the court would be unlikely to be interested in a case if that really were all that it was about. And the court actually only granted certiorari on the second question, which quite clearly asked the court to overrule Chevron. And obviously then the second part of that question said, otherwise clarify that silence in the statute. So by not saying that other vessels don't have to pay, that doesn't mean that there is ambiguity. The court chose to ignore the second part of that question, obviously, because it went ahead and decided to overrule Chevron. The decision was a 6-3 decision. It did split along political affiliation, with Chief Justice Roberts authoring the decision, the majority decision of the court. Thomas, Alito, Gorsuch, Kavanaugh, and Barrett joined that. Thomas and Gorsuch did also write concurring opinions. And then there was a dissent by Justice Kagan, joined by Sotomayor and Jackson. Jackson participated in one of the cases, but couldn't participate in one of the others because of conflict. Okay, so what does the majority do? The majority decision in Loper Bright, obviously, as I've mentioned before, and as you all know, it overturned Chevron. And it did so explicitly. And it starts, as many recent Supreme Court decisions start, with really an overview of history. And when you start reading the case, you might think that the court was making a decision on constitutional grounds, but it did not go that far, even though that is what Justice Thomas would have preferred. But the court did start by talking about Article 3 and the Federalist Papers in Marbury versus Madison, pulling out these principles. The court said that federal courts are the ones that have the authority to interpret laws, and that has been consistent. It's consistent in the Constitution and the Federalist Papers, and was articulated in Marbury versus Madison. The court then acknowledged that, from the very beginning, federal courts often accorded due respect, or they said very great respect, to executive branch interpretations of federal statute. But here the court made sure to limit, its review of history and said, first, these were interpretations that were issued near in time to the legislation's enactment, so contemporaneously with the statute, and when the executive interpretation remained consistent over time, right, which shows you that part of the reason why the majority, was reaching this decision again is the concern about flip-flopping changes in statutory interpretation that result when administrations change and revise their regulations. The court went on to say, though, that historically this has just been about respect, and that courts were always still the final arbiters of what the law meant. And so they were required to use independent judgment and were not deferring in any way to an agency's construction of a statute. And throughout this discussion and really throughout the opinion, the court really analogizes what went on historically to the more recent doctrine in the 1940s of Skidmore deference, which is definitely still alive today, and the court thinks is an appropriate level of deference, and we'll come back to that. After going through history, the court, though, sort of puts that aside and then turns to the Administrative Procedures Act. And this is really the hook because Chevron, the decision itself, did not address the Administrative Procedures Act at all. And so the court points out that Section 706 of the Act, in its mind, codified that historical tradition by stating that courts were required to decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. So the court relied on Section 706 of the APA and decided that required the courts to provide a de novo review in most cases of congressional statutes, and that had been overlooked by the Chevron case. Again, the court comes back and says that it's not as though agency expertise or experience doesn't matter at all. Court will look to that for guidance, and using Skidmore deference, which in administrative law has often been panned as just the amount of deference that a good litigator gets from the court, not really anything more. It's basically, the court will be persuaded if you present a persuasive argument, if it's well reasoned, if it's consistent, if you have expertise, etc. And so that's what the court is saying here. It's not deference. It's providing some respect to the agency's interpretation if it is really well thought out and well reasoned. The court reiterated its theme that it had in the historical section, that interpretations that were issued contemporaneously with the statute that remain consistent over time are going to be especially useful. And this really goes to the way the Supreme Court views statutory interpretation in general. The Supreme Court has consistently in recent years viewed statutes as being as interpreting them as static with the meaning that Congress intended when they were passed. And that might sound really obvious to everybody on the CLE, but it's not a principle that is held in plenty of civil law countries, for example, where the meaning of statutes would evolve over time. But that is the way the Supreme Court has interpreted statutes. And so therefore, it's basically saying the most persuasive executive branch interpretations will be ones that were close in time to when the statute was originally adopted. Again, the court emphasized multiple times that it's got to provide its independent judgment. So it really is reviewing this de novo and trying to reach decision about what the statute means. There were, as I mentioned, concurrences and dissents, with Thomas emphasizing that Chevron deference violated, in his mind, separation of powers under Article 3, and Justice Gorsuch writing separately about stare decisis and why that's still supported overruling Chevron. Justice Kagan's dissent, joined by Sotomayor and Jackson, really highlighted the arguments for Chevron that I mentioned before, that have been really well developed in the literature and in the original case, that they reflect a deference to the agency because that is what Congress would probably intend, because the agency should make policy judgments, not the court, and that it is necessary to resolve certain ambiguities or gaps in statutes. So takeaways and potential impact of Loper Bright. First, the court is clear that there may still be instances where a court will defer to a reasonable agency interpretation. The court has just greatly narrowed that and said it really is looking for something that it views to be an express delegation of interpretive authority, and not what the court was previously doing, which was implying that by entrusting an agency with the authority to promulgate rules and to administer a particular statute. So the court is going to look for something that it views as an express delegation. And then it says that it would recognize that delegation as long as the agency was engaged in reasoned decision-making within the bounds set by Congress. So this would be a significant amount of deference, but it's in a narrow category of cases, or we think it's in a narrow category of cases. The court goes on then to provide some examples of what I think we would consider to be really express delegation, where it literally says in the statute that Congress is delegating the authority to the agencies to define X, Y, or Z. The court provided some examples of that, but also noted that the statute could empower the agency to fill up the details of the statutory scheme, and that it could provide a delegation by simply using language such as appropriate or reasonable. And so if Congress, asks an agency to make, appropriate and reasonable regulations in this area, then the court's basically saying we would grant deference to the way the agency was interpreting that. So we'll have to see how that plays out in lower federal courts and how much space this exception takes up. In terms of statutory construction, now this is going to be even more important because the court is signaling here that it is going to interpret statutes de novo and not provide deference to agencies, and instead just use what we would refer to as Skidmore deference, which really isn't deference. It's being persuaded by the agency's viewpoint if you think it is based on expertise and thought and a reasoned position, et cetera. So the court is going to be engaging in statutory construction. You normally would go into this thinking, okay, that's going to be a lot of emphasis on the plain language of the statute and dictionary definitions, because that's certainly the way the Supreme Court has trended in its statutory construction in recent years. But what was really interesting to me in reading Loper Bright is the court didn't really engage in that type of statutory construction by itself when it was analyzing Section 706 of the APA. The court, went far beyond the text, referred to House and Senate reports. So those are the kind of the highest level of legislative history you would see, but then also cited supporting statements or positions that supported the court's position by individual legislators, right? Things that they had said on Congress's floor or in committee meetings. And it's been a long time since we've seen the Supreme Court, particularly the conservative majority, going out of its way to cite legislative history. So I'm not sure what to make of that, whether the court realizes that the more de novo review it does, the more tools it's going to need in its toolkit to be able to figure out what the meaning of the statute is. But it might be a way to argue anew that some of these other means of statutory construction are really important. The context of the statute, canons of construction, the purpose, legislative history, and policy or consequences. I did admittedly find it a little bit amusing that the court was very sure that every statute still has a best meaning that the court could discern from deploying its full interpretive toolkit. I will say the justices must be a lot smarter than me, because I am confronted with a lot of circumstances in my job as a state court judge where I am unsure what the law means and find there to be ambiguity, and are trying to use all the tools in the toolkit and still remain unclear. But the court feels that there is a best meaning and that it can discern that best meaning, a single best meaning from the tools of statutory construction, and said that a number of times in the decision. Okay, so what will happen now that we've jettisoned Chevron? The majority said that it was not calling into question prior cases that relied on the Chevron framework. So remember that number of 18,000 cases. Loper, Bright obviously would cause a lot of folks to gasp about, well, what's going to happen to all those different interpretations of statutes out there. The court claims that just because it's changed its interpretive methodology doesn't mean that it is not going to grant statutory stare decisis to decisions under Chevron. I remain a little bit skeptical, to be honest, of whether that will be true if we're talking about decisions under Chevron Step 2, where the court deferred to the agency's reasonable interpretation of the statute. It's certainly, the court is not saying that they're immune from challenge, but is saying that they will apply statutory principles of stare decisis, which normally you wouldn't think would be applied when deference is used. So we'll have to see how that plays out. Everybody, I think, is predicting there's going to be an increase in litigation as a result of this. Without agency deference, the hill is not as steep for litigators. You can just argue about what you think the best meaning of the statute is to the court. And so this is likely to result, at least in the short term, in a lot more litigation. There also, when you combine this with some of the Supreme Court's other recent decisions, like the decision this term in Corner Post, it may mean that there is a hook to bring a lot of those challenges, that the statute of limitations wouldn't have run unless the plaintiff was injured. And so it's at that point that the 6-year statute of limitations would run. So that might open the door to more challenges than you would originally think would be available. We're likely to see an increase to some extent in forum shopping. I think we've already seen this in recent years. There's been an emphasis on bringing, it used to be that administrative law cases were almost always brought in the DC Circuit because of the DC Circuit's expertise in administrative law areas. It gave most practitioners a lot of comfort with having their cases heard there. And of course, you can always sue the agency where they're located, which is likely in DC, or where you're residing, or you're feeling the impact of the rule. And so most of the litigation has been in the DC Circuit, but we've seen in recent years an uptick in litigation being filed in the Fifth Circuit to get that differing opinion. And I think that is likely to continue. There will also be more circuit splits because there'll be less uniformity. And the Supreme Court acknowledged this, that this was an argument the parties made. It was raised by the defense. If we're deferring to an agency's reasonable interpretation of the statute, as long as it's reasonable, that's likely to have a nationwide effect, right? The agency's regulation. But if in each jurisdiction you're arguing about what the statute means de novo, and you're not deferring to the agency, that's creating the likelihood of many different interpretations of the statute, where only the US Supreme Court could resolve those splits. And as we know, Supreme Court doesn't hear a lot of cases each year. So there is likely to be a lot less uniformity from jurisdiction to jurisdiction. And then this question of whether, nationwide injunctions are going to be litigated. And it may create, a mess as you've got attempts for nationwide injunctions and then emergency stay applications in federal circuit courts that are always very difficult to handle because of the short timing that exists there. So we are expecting that, I think, in light of the decision. One of the things that I wanted to flag, though, is the court obviously spent a lot of time talking about Skidmore deference and how that remains. And again, Skidmore deference basically says the weight an agency's interpretation is given depends on how persuasive it is, its thoroughness, its reasoning, its consistency, its overall power to persuade. But there is another type of deference in administrative law, Auer deference, based on Auer versus Robbins, and actually a case before then, but the Auer case is from 1997. This is about deferring to an agency's interpretation of its own regulations. So Chevron is about an agency's interpretation of a statute, and Auer deference is about an agency's interpretation of its own regulations. The setup for Auer deference was very similar to Chevron deference, but the court considered how to limit that more recently in the Kaiser versus Wilkie case from 2019. And that decision went in there and limited Auer deference by saying, we'll apply this deference only if we really are sure that the statute actually is genuinely ambiguous and that the agency's interpretation is reasonable. And then adding to that, the interpretation is the agency's official position. So not wanting to see something like a low-level official offering their view of the statute or a litigation position or some sort of post hoc rationalization, right? So they wanted to see that's the official agency position, and then that the interpretation does in some way implicate the agency's expertise. The Auer follow-up, that Kaiser case, is so recent, but there were 4 votes that wanted to eliminate Auer deference. And since then, Justice Ginsburg has obviously been replaced by Justice Barrett, in light of the way Justice Barrett voted in knocking down Chevron and eliminating Chevron deference. I would say that Auer deference is really in a quite precarious position at this point. So we could be left pretty soon with just having this Skidmore level of deference, whether you're interpreting statutes or regulations. So other sorts of thoughts and questions about what might happen after Loper Bright. Will the pace of regulation slow? I would certainly think that agencies would be less inclined to engage in notice and comment rulemaking to interpret a statute, since it is so time-consuming and expensive for agencies to engage in that. And agencies were really prompted to do that in part because of Chevron. So now I think you'll likely see a lot fewer regulations along those lines. And if anything, more pronouncements maybe in interpretive documents, like in agency handbooks or bulletins or guidelines. So the pace of regulation may slow. Obviously, I think agencies are going to realize that their decisions are only going to get deference, at least if you're interpreting statutes, is only going to get deference if the court is convinced by them. And so they're going to have to tread a lot more carefully now that there is no more deference. It could be that there is a trend to use more formal adjudication instead of notice and comment rulemaking. There aren't too many agencies that have used formal adjudication to interpret statutory provisions, but the National Labor Relations Board is one of them that uses formal adjudication in that way. So we'll have to see if that happens. Obviously, I noted that the statistical evidence said that Chevron helped court decisions in this area be less partisan. So there's a question about whether now they will be more partisan without that agency deference. Will Congress amend the APA to restore Chevron? I'm just not. I'm not convinced that has a chance of making it through Congress. But there already has been a bill by Senator Warren introduced to try to do just that. One of the important parts I would say is that parties are going to have to work a lot harder to educate judges on what can sometimes be really technical matters and how statutes actually work in practice. Because if you're a federal court judge, you're not really familiar with, you're jack of all trades. You have to be familiar with so many different areas of law. You're not going to be familiar with the ins and outs of how a particular statute operates on a day-to-day basis, and certainly not with the technical aspects of it. And so this may result in a need for more amicus briefs at lower court levels, and not just in the U.S. Supreme Court, briefs that can target those specific areas. And the last thing I want to talk about, and then hopefully there is a little bit of time for questions, is about impacts on state administrative law. So, of course, Loper Bright is about Chevron, which was about giving federal agencies deference in their interpretations of federal statutes. But Chevron never applied in state courts to whether state courts should provide deference to state agencies' interpretations of state law. And it may or may not surprise you to know that the law here is pretty much all over the map. And literally, there is a map that you could look at that's in the resource there on the left-hand side of this slide. Daniel Ortner has come up with it. It's gone through a couple of different iterations to show whether states are, which doctrines of deference they're applying and which ones they aren't. And even before Loper Bright, there were a number of states that did not apply any deference, like Chevron deference, when it came to state agencies' interpretation of state statutes. I believe, for example, Florida and Utah and Mississippi, and I think Wisconsin don't apply, and there are others, don't apply any deference in state court to state administrative agencies' interpretation of their statutes. Minnesota is a little bit more of a mixed bag in terms of these deference doctrines. But when it comes to Chevron deference, Minnesota has something close to it. And I've given you some of the cases there that, obviously the state court doesn't provide deference if the statutory language is clear. But if it is ambiguous, an agency's interpretation of the statute it administers is entitled to deference and should be upheld unless there's a finding that it's in conflict with the express purpose of the act and the intention of the legislature. So it's not quite the same as the Chevron Part 2, but it's close-ish to it. So we'll have to see whether after Loper Bright, state courts will also start to, if they have adopted something like Chevron deference, are they going to start to turn away from that and engage in de novo review across the board? So that was basically about 50 minutes on Loper Bright. And I'll come back to, it looks like there's only one question up here so far. So if you do have questions, feel free to jump into the chat and put some of your questions in the chat. Um, the Supreme Court said the APA was ambiguous. It did not. The Supreme Court did not say the APA, the Administrative Procedures Act, was ambiguous. It thought the language in Section 706 was clear. So you could say that it was just using, legislative history to bolster its argument, if you will, but it's not something that we've seen with any regularity in the Supreme Court, even a reference to legislative history. Seen more of a disdain for legislative history. So I was surprised to see that section of the opinion. And again, if you truly believe that statutory language can be ambiguous, the court is going to have to resort to some of the other tools that it does have in order to come up with what it believes is the single best reading of the statute. And some of those other tools of statutory construction also have been out of favor with this court. One of the things on that list, for example, was canons of construction. Before I was a state court judge, I spent a lot of time working on behalf of Native American tribes. And there are a lot of canons of construction in the field of Indian law, like canons that say things like, if there are ambiguities, we should resolve them in favor of preserving tribal interests. And we should liberally construe statutes in favor of tribal interests. But the Supreme Court has been really reluctant in recent years to apply those canons in the field of Indian law, and has been with respect to other canons as well too. So it will be interesting to see how that plays out.
Judge Rutel, I do have one other question that's come through on the chat. It looks like just to
Great.
me. The question reads, is this a case of bad facts make bad law? What was that fisheries agency thinking when it persisted in this assessment of fees? And why was there no recognition of the litigation risk?
Yeah, so I don't think it is at all a question of bad facts make bad law from the standpoint of the Supreme Court could very easily have not addressed Chevron at all and said the statute here is clear. And you know what they could have said when we were talking about silence, we didn't really mean it in this way. We meant ambiguity or silence that creates ambiguity. And here the statute clearly delineated 3 times where you could require the industry to pay for observers, and so you can't create a 4th unless the statute uses that language that says including or something like that, where we would say that as a matter of statutory construction, it's not limiting it to the 3 that are identified, right? The court had the ability to do that, but really had no interest in engaging at all with the statute itself, the statute's text, whether it was clear or resolving this in any way on Chevron step 1. And that's why the court, did limit the question presented to overruling Chevron. And I think was just looking, it had an opportunity to grant cert on another case last term where it could have, overturned Chevron as well too. But I think was just looking for a good vehicle for it to issue this decision. Somebody else asked in the comments whether Congress could, if it wanted to, codify some sort of Chevron deference, and I think the answer to that is yes, potentially, based on the way the court opinion reads. I'm not sure that Thomas would agree with that approach, Justice Thomas. He might find that that would violate constitutional separations of powers principles. Although he didn't, he certainly said that Congress could delegate interpretive authority to agencies, and the courts would respect that. Really signed on with that part of the majority opinion. But the majority here seems to be based on, a statutory reading of the APA. And the real hook here is that the Chevron case itself didn't reference the APA at all. It was creating a common law standard in ignoring the statutory framework. So yes, I think Congress could make that change through amending the APA. I just don't think it's very likely because it has become such a politicized issue. Even though it once was viewed as really favorable by conservatives, it is now very disfavored by conservatives. So it just seems like it would be challenging to get it through Congress. Um, just trying to go back and find the original question that Paul wrote here. Does it distinguish between issues of legal interpretation, what does ambiguous term mean, and those of policy? Um, not really in that way, but I will say the court did did indicate when it was talking about Congress providing some, statutory delegation so an agency could interpret um, a statute if it was doing this expressly. It did note that in a lot of those circumstances, they would be more factual type of determinations. So, believe it highlighted things like whether a newsboy is considered an employee. So they were really viewing the potential delegations that Congress would provide to agencies that the court would then provide deference for as being these really mixed questions of fact and law that were pretty fact intensive, as opposed to what it saw as a lot of the cases that were falling under Chevron step 2, which really were pure legal questions that the court said, judges are more equipped to handle than agencies are. And it looks like there's a question about impact that would have on agency administrative decisions. Um, uh, I guess it depends on, is the agency administrative decision. You would think that that is going to rely on the agency's interpretations of statutes. And so to the extent it is, it may result in more overruling of those types of decisions by federal courts. Um, whether it's a statutory structure that allows for a direct appeal to a federal court of appeals or requires filing a new complaint in federal district court, I think it could, lead to more reversals to the extent that the administrative law judge is inclined to follow agency interpretations of a statute, and then the state, and then the federal court is going to conduct a de novo review of the federal statute instead of applying deference. Um, so I do think that that's possible, although I can't say, what types of questions in particular you might be looking at on, when it comes to EEOC. Okay, well, Ms. Larson, unless you have any additional questions, it looks like we're pretty close to um, the cutoff, but I'm happy to take any last ones that have popped up.
I don't have any here, so everyone on the call, this is your last chance to enter a question. Um, in the meantime, I will just say thank you so much for providing this presentation. I think it was really informative and a rapidly changing area of law that's going to be very interesting for all of us to watch. So I appreciate this presentation. And I think with that, we'll go ahead and conclude. Thank you everyone for attending.
Okay, thank you.